All right, I'll go ahead and get us started. My name is Kristen Stratton, and I am one of the co-presidents for the Go Bananas organization. And it is my pleasure to be hosting the presentation that is going to be presented by Jeff Nickerson. This is our second of a four-part series, all on various topics that Jeff has so generously donated his time to share with us that are all very, very important topics that are typically brought up over the months. We just probably get asked these same questions probably a dozen or more times. So we appreciate his expertise. Tonight specifically, we're going to be talking about conservatorships and alternatives. So I will say that one of the things Jeff really is wonderful about is taking questions. So if you have questions throughout his presentation, I will be happy to interrupt him politely and share those so you can put them in the chat box. And I will use the opportune time to interrupt him and share those with him. And then time allowed at the end of the presentation, we'll also have an opportunity for Q&A. But thank you for joining us, and I'll turn it over to you, Jeff.
Well, thank you and welcome everyone. I really enjoy doing these presentations. Um, for the past many years, I've done a lot of estate planning presentations and tried to cram everything into one presentation. And what we did here is we've broken it up into four different presentations, which I think is far better. We can delve down a little bit deeper and you're not getting hammered with just so much information. Thank you, Kristen, so much for hosting. I do enjoy questions. I think it brings everything to life. If you have any questions, I'll certainly share any of my experiences I've had over the years and share those. We're going to cover the broad range of conservatorships. I'm going to talk about the different types. What are the alternatives? Can you set up a conservatorship yourself? Yes, you can, and we'll talk about that. So, anyways, let's jump right into it. I believe you can probably see my slides. Is that correct?
Yes.
Good, thank you. So first, we have to have the disclaimer, and you see this on every time you see a presentation. The following is legal information, not legal advice. And so, why do we say that? And the fact is that when I'm talking to somebody, I'm gathering information, and a little fact can make a big difference. So, for example, if somebody is receiving SSI, I'm going to tell them a whole bunch of things. If they're receiving SSDI, I'm going to tell them a whole bunch of different things. So talking about special needs planning, how to set things up is what we call in the law school very fact specific. Um, uh, Background about me, you don't really need to know much about me. Way too much education, but I've always enjoyed going to school. Got my law degree, went into something entirely different. Um, with Was aerospace, spent many trips to Israel. Probably went there 11 times supporting their military. And so I'm it's very fascinating to see what's going on these days now. Probably the biggest thing you need to know is I've got two sons that were diagnosed with special needs, one with autism and one with cerebral palsy. So I've been through all this. I've been through the schools. I've been through all this. And so I know how complicated it is. I know how challenging it is to raise somebody that's a family member with special needs. I know how expensive it is, uh, but we all do it for our love of our family members. So who needs a conservatorship? At age 18, this is key. At age 18, the law presumes there is a legal presumption that you are competent at age 18. The problem is, because of that, many providers, physicians, financial people will not talk to you if you have a child that's now turned 18. Now, many will, especially if you're with had a family doctor that's been dealing with you for years and years and years, and they just may just continue to dealing with you. But some organizations are very strict about this. I know Kaiser is very strict. At age 18, you go from pediatrics to an adult, and they're very strict about talking to people and with financial advisors. So anyways, so at age 18, some action is required. You got to do something. And that's everybody. That's whether you're disabled, special needs, or not. Everybody should have something in place when they turn 18. So what is a conservatorship? A conservatorship is a court process. It's a judicial process where a judge appoints someone, that's the conservator, usually the parent, it could also be an older sibling, or it could be really anybody else, but usually it's a parent or an older sibling, to manage the personal care or the finances of an adult, somebody who's turned 18, and we call that the conservatee. It is the government taking the rights away from that individual and giving it to somebody else. That's a big deal. We have a history in our country of freedom, and so taking the rights away from somebody is treated very seriously and requires lots of documentation, lots of what we call due process to make sure it's the right thing that's happening. It's a very detailed process, very specific steps to ensure it's really needed. It can be confusing and frustrating, but it's necessary to protect the conservatee. I know I talked to many parents, and their child turns 18, and they're going, "I'm their parent. Nobody, I have the right to do this." Well, actually, you don't. That's why you need a conservatorship. Just every other state, of course, California, we do things differently. In California, we call it a conservatorship when somebody reaches 18. Every other state uses the term guardian. In California, we speak of a guardian who's somebody under 18, and a conservatorship, so from somebody that's 18 and over. So before I get into the details of conservatorship, there are alternatives. Like I said, everybody needs something. All of you need something if you don't have something in place. So the most common alternatives is a financial power of attorney and advanced healthcare directive. Also, we'll talk briefly about supportive decision making. I haven't done a lot of those, but we'll talk about it right at the end. So in California, there's two major types of conservatorships. That's unique to California. Most states only have one type. Here in California, we have two types. We have the general conservatorship that I've all heard about forever. And because of the limited conservatorship, generally the general conservatorship is geared for somebody who's older, lost mental capacity. Oftentimes it's older, some with cognitive dementia issues, Britney Spears. And then we have the limited conservatorship. Again, very unique to California. Limited conservatorship is just for those individuals with a developmental disability. As a matter of fact, the way the courts are set up now, if somebody has a developmental disability, they have to get a limited conservatorship. They are not eligible for a general conservatorship. It's a horrible name. I'll talk about that in a moment. So again, typically the classic developmental disabilities is autism, cerebral palsy, Downs, those types of things. There's an entirely different conservatorship, a very special one for those with mental illness. It's called an LPS conservatorship. I will talk about a little bit. It's very limited, very difficult to get, and again, I'll touch briefly upon that. So within the two types of conservatorships of general conservatorships and conservatorships limited conservatorship. Within those two, there's conservatorship of the person and conservatorship of the estate. So it's pretty obvious what conservatorship of the person means, controlling that person. The estate is just managing their assets. Whenever we're talking about conservative of the estate, it gets much more complicated. There is annual accounting that's very detailed. Annual reports have to be submitted to the court. It becomes very cumbersome. Generally, most of our family members that are turning 18 generally don't have an estate. And typically, if they do, we try and get it out of their estate and in some and someplace else. So I've got parents that come in, they've been putting away money for all these years for their child. Unfortunately, they put it in their names, and and um, and we don't want to do that because we don't want to go through all the cumbersome and expense of a conservatorship of the estate. What we'll generally do is we'll pull the money out. These days, the great solution is what we call an ABLE account. We're going to talk about ABLE account in detail in a future presentation in July. So again, by the person of the estate, just about always for a limited conservatorship, we're just talking about a conservatorship of the person. I'm going to talk briefly, I said, about LPS conservatorship. Um, I have a real passion for mental illness. The mental illness is not considered a developmental disability, and it is very difficult for a parent to have somebody, an adult child with mental illness. Um, a conservatorship can be attained for somebody like that. Very difficult. They have to meet some very specific criteria. I've got it listed in the chart. They either have to be gravely disabled, gravely means like near death type thing, or a danger to self or others. A private attorney like me cannot bring a LPS conservatorship. It's only done by the public guardian. A private person, private attorney cannot bring a conservatorship. It's only if usually there's a whole bunch of steps. There's some various holds that have to be gone through, and it can only be granted for 1 year. That's got to be renewed. Um, there's a lot of detailed rules about locked facilities and so forth. It's been frustrating for me. I've actually I joined and serving on the Temecula NAMI board of directors just because trying to find solutions for families. So the reason for, again, a few final comments about the LPS conservatorship. There's a horrible history. This is usually pre-1960s of locking people up. If they had a mental issue, they were locked up, and so they established the LPS conservatorship to combat those abuses that were done well, 50, 60 years ago. The problem is they kind of went too far the other way and makes it almost impossible to help people who need help. Those are my comments. Oh, okay. So let's talk about a general conservatorship. Um, just a year and a half ago now, passed AB 1194. We call it the Free Brittany Bill, and Brittany was probably kept under conservatorship much longer than she should have been. And so they've passed a bunch of rules about have a right of attorney. They didn't used to have a right of attorney. They figured, well, if you're incompetent, then you're not competent enough to hire an attorney. So that was changed. That was a good thing. Um, uh, the problem is that when somebody says, I don't want to be conserved, then there's got to be a full-blown trial. And the trial, medical experts and the whole thing, which can get very, very costly. So you're trying to, grandma's acting funny. She's, entering all the sweepstakes and, publishing clearinghouse and so forth and just going crazy financially. And so people come in, oh, I need to get a conservatorship over grandma. She's, doing crazy things. If in court, grandma says, I don't want a conservatorship, you're into a trial. And any funds that come out for attorney fees or expenses, court expenses, any medical experts, all that stuff, unless the conservatorship is granted, it cannot come from the conservative estate. So the person who wants to put grandma under a conservatorship for her own good now has to be at risk for, could be tens of thousands of dollars. And most attorneys I know are not even taking general conservatorships. So that's about all we're going to talk about general conservatorships, because what we're focusing on today is limited conservatorships. A horrible name. It's limited to adults with developmental disabilities. There's a California probate code, which I published. The California probate code is about this thick, and there's like thousands of pages. Um, so what it constitutes a developmental disability? It's a disability that originates before age 18, continues or can be expected to continue indefinitely, and constitutes a substantial hardship. So that's the description right out of the probate code. Limited is a terrible name because people think, well, it's limited. It's not near as good as the full thing, and that's not correct. There are 7 powers that are taken away or limited from the proposed conservatee and granted to the proposed conservator, again, usually the parents and maybe an older sibling. Um, Almost always, like I mentioned earlier, we're going to set it up so when we're doing a limited conservatorship, it's going to be of the person, not of the estate, just to avoid a lot of extra expense and accounting and so forth. So here's the 7 rights. So the right to determine residence, the right to access confidential records and papers, to consent and withhold consent to marriage, the right to contract, the right or to give or withhold medical consent, the power to control social and sexual contacts, the power to make educational decisions. So those are the 7 powers. It really covers just about everything you can think of. Interestingly enough, when we're doing somebody that's, I would say, high performing, and the 2 they always take exception to, always, is the consent or withhold consent to marriage, or the right to give, or the power to control social and sexual contacts. We see that all the time. What we often can do is we can have that right shared, so it's not taken away from the conservatee, but it's granted to the conservator. In my opinion, the effect is the same. Um, uh, and frankly, I found that there are bad people that try and marry elderly people for money and so forth. Once somebody finds out um, that the conservative doesn't have any money. So here's a story. My son right now is in his 30s. But unfortunately, he's always on the internet, and he got contacted. This has happened a couple times now, where he's been contacted by beautiful women, all these beautiful pictures. I don't even know if they're women. Who knows? They are probably some girly guys in a back room, but are trying to romance him and so forth, and and has convinced my son that he's found a new girlfriend. We try and tamp it down, but at one point, I actually got on a text and I said, you know what? The person you're talking to is developmentally disabled. They have zero money, and instantly that person disappears. No. Um, Grab some water here. Do we have any questions at this point, Kristen?
You do, but it will probably be more appropriate to ask a little bit further. But I did
Okay.
have a question, because I do think sometimes the right to vote comes up. So can you speak to that?
I'm sorry, say that again. Speak to what?
The right to vote.
Oh, yes. Well, yeah, I'll talk about that now. That is always a major deal. And the courts always address that all the time. It's a big deal. So courts are hesitant to restrict voting. On the other hand, if there's a clear inability to articulate a desire to vote, they will restrict it. Our current judge here in Temecula, Judge Rushton, he is very he watches that closer than most judges. He's actually had set hearings years later where it was marked they don't have the ability to articulate, and he'll call a hearing just to readdress that and investigate. So he's very aggressive to it. Other judges in the county not so much. Okay, so what is the test on what is in the law? We always have a test on everything. So the test of whether somebody can they articulate a desire to participate in the voting process? And so obviously if somebody can't speak or doesn't have any other way to communicate, then they can't articulate a desire. Um, but it's not, can they vote? Do they have the ability to vote? Or you don't like the way they want to vote? That has nothing to do with it. is can they articulate a desire to participate in the voting process? I was in court one day, this is fairly recently, about a month or two ago, and the examiner that had met with the conservatee, and I'll get into that in a little while, stated that the proposed conservatee said she did not want to vote. Well, interestingly enough, the courts then said we are not going to restrict her voting because she could articulate a desire to participate, and her desire was not to participate. That's not the test. Whether or not you want to participate, do you have the ability to articulate a desire to participate? So, um, anyways, that's something I always include, and I have a separate conversation with my conservators when we meet in the prior to the court hearing. Because no matter what's checked on there's a box in the petition and on the order that addresses that. When we're filling out these documents, we never restrict voting. We always err on the side that, and then usually that comes up during the hearing. That's probably a long answer to the voting, but it's a big deal. So that's why I went on for a while.
Thank you.
Um, the limited conservatorship process. It is a process. So I'm going to go through with it and not dwell on all the documents, but I'm going to show you all the documents here in a moment. So the first thing to do is gather all this information. So we meet with the proposed parents and gather as much information as we can. Usually a lot of that information can be pulled from school IEPs and those kinds of things. So it's not that difficult. Pulling all that information, putting together what we call a petition. A petition is what we do, and it's usually a very thick document we submit to the court that has all the arguments as to why a conservatorship is needed. At that point, once it's submitted, usually the same day, we'll get a court date. We were getting court dates in December. All of a sudden, we've been getting court dates in October. It was running about 6 months, and now we're running about 4 months. So you need to plan ahead at least 4 to 6 months prior to somebody turning 18 if you think you need a conservatorship. So once we get that court date, we have to send notification out. And some people object to this, but we need to send out notification to all what they call first and second degree relatives. And so that would be parents, grandparents, if they're still around, siblings, all have to receive what they call formal notice. And we have to file a document called a proof of service, where we have to swear to the court that it's been filed, it's been dropped in the mail, or however we process service. Big deal. At that point, we'll have a court date, and we'll know what court it's going to go to. Here in Riverside County, we have 4 courts. One here in Temecula. We have 2 in the old historic downtown courtroom, and then we have one out in Palm Springs serving the desert. We have to get what we call a capacity declaration. I said that it's a doctor's evaluation, and the doctor's evaluation is key. We have to have a doctor's evaluation. It has to be filled out correctly. It has to be signed in the right spot, and the doctors always mess this up. So that we actually tell our clients, get that done as soon as you can, and then we'll get it back to us. We'll review it, find out what's wrong with it, and send it back. It can only be done by a physician or a licensed psychologist with a medical degree. Can't be done by a nurse practitioner. Can't do it with a physician's assistant, which is dumb because I think those people are highly qualified to do that. But the courts aren't listening to my opinion on that. But anyways, we stress getting it, and that's why I'm stressing it so long, is getting that capacity declaration. Some doctors refuse to do that. And so fortunately, we do have 3 or 4 physicians. Most of them are located in downtown Riverside that will do the evaluation. So if you have trouble getting your doctor for whatever reason, every once in a while they say, well, I don't have the experience in this stuff, I can't fill it out, we can find physicians to do it. The courts will assign an attorney to represent the conservatee, and they'll meet with the conservatee. They'll talk with them, and they'll do an evaluation and express an opinion about what. Let me rephrase that. They'll be in court and they'll address that. If your conservatee says, "I don't want a conservatorship," the attorney representing that your conservatee is required to argue that point, argue to the court that a conservatorship is not necessary, even if they believe it's needed. Um, um, the conservatees will interview usually the conservatee and the family. They won't go outside that. The courts will assign an investigator, and that was one of the things that was backing up our hearings for so long. Was there was in Riverside they were short of court investigators. They'll interview the conservatee. They'll meet with them, hopefully alone, unless it's a real problem. They'll read them their rights. And don't worry, they both the conservator and the attorney and the investigators, they're used to dealing with people with disabilities, but they'll read them their formal rights. They'll ask a series of questions, and then they'll write a report, a detailed report. It's usually 4 or 5 pages long, and we'll get a copy of the report. We always send that off to our clients so they get to see it. Typically, they're almost always recommending a conservatorship because, and I'll get into that in a moment. Generally, we're leading our client into a successful um, uh, outcome. The regional center also does an evaluation, and so regional center has to do evaluation. It's part of the law. And so if we run across people that have never started regional center services for whatever reason, don't do that. If you have a child with developmental disabilities, get them signed up, get regional center services. It's unique to California. It lasts a lifetime. I think on our next presentation in July, I'll be talking about the very benefits and go into that detail. I suspect most of you are already getting the vast majority of my clients, but the people listening here probably already have their son or daughter as clients at Regional Center. But it surprises me that every once in a while we get one they've never started the process. And so if they haven't, we got to start the process, and there's a whole long intake. Those of us who have had family members go through, it's always kind of a process to go through the regional center, especially if you're starting later in life. So we got the attorney representing the conservatee doing an evaluation. We're having the court investigators, they're doing an evaluation. We have the inland regional doing an evaluation. But there's even one more. The court has what they call attorneys, probate attorneys. Riverside has 3 or 4 of them. They'll review all the documents and they'll make notes they'll find things that are wrong. They'll write that to the judge. Fortunately, Riverside County, they're really pretty good, and we'll get those notes back early on, usually months ahead of time, so we have a chance to fix them. But if there is on these lengthy court filings, various documents we have to provide, if there's a box that isn't checked right, we're going to get a deficiency notice, and we got to go fix it. And we're pretty good about doing that, but it can be very frustrating for somebody on their own who doesn't even know about the notes to be fixing it. And finally, then there's the court hearing. So this has been all the stuff we started, and then all these paperwork going back and forth, all these investigations going on, documents going back and forth. Finally, we have a court hearing. So we walk into court, and usually it's at that point, it's pretty perfunctory. They'll call us up and they'll talk to the attorney will be there. They're representing your son or daughter. They'll express their opinion. Well, first of all, we introduce ourselves for the court record. They'll ask the other attorney. They'll ask him if there are any questions. They'll talk to me. Sometimes the court will talk to the parents, and then usually they'll, unless there's something strange that comes up, nearly always it'll be approved at that point. And it's a very perfunctory hearing. They have to have an open court as part of the law, but usually we're in and out within 2 minutes, 3 minutes, 5 minutes, unless there's some oddball issue. What you will get then is what they call letters and orders. It's 2 documents. So it's orders by the judge to create letters, and then letters is your authority to be a conservator. I'm going to show you examples here in a moment. The letters is what you would provide to the school districts, to anybody else that wants proof that you have authority over your conserved adult child.
Jeff, you have a couple questions.
Sure.
The first is regarding amending an existing conservatorship and how to go about adding a secondary conservator, like a sibling, for example.
Yeah, unfortunately, we got two of those going on right now, and it's very frustrating because we have to go through just about the same process. The only thing that's different is we don't have to have the proof of the conservatee um, being disabled because that's been established already. So we don't need a capacity declaration. Other than that, it's all the same paperwork, all the same investigators, the attorney representing the conservatee, they get involved, the court investigator. Um, I don't think we need a review. I think we do need a report from regional center. So it's unfortunately it's nearly 90% of the same work to do. So I always talk to people, if you have like an older sibling, that would be, let's get that started from the very beginning. And the reason why that's important is if the conservator passes away, conservatorship just ends automatically. So we really want to have somebody that's younger as part of the conservators.
A follow-up question to that, do those people act as an either or only as a successor?
No. So so the court nom names conservators. So it's not like you can name a successor conservator and just as a backup, like you can on a trust, where you have successors just sitting there waiting until something happens to the name conservators. So we've got to name everybody has to be named as conservators, and they must agree, and that's really important. The court will actually usually says something when we have like three people, the parents and maybe an older sibling. They'll remind them that you have to be in agreement uh, on everything that's done. Um,
Thank you. And then the next question was regarding a clarification on the notification sent to family members. For example, if the siblings are younger, or if there is an adoptive situation, would any of the adoptive family members be notified? Or what if there are other family members who are also developmentally disabled? What is the limit to that notification tree?
I, I think there's a different answer to each one of those. So
Yeah.
if their siblings under 18, they don't need to be notified. If somebody has actually formally adopted, it's not like a foster child, but they formally adopted that individual, then the birth parents do not have to be notified. The If there's somebody else that is developmentally disabled, an adult. So hopefully they have two things. Hopefully they have a conservatorship, so the notice would go to the conservator, or they have a financial power of attorney that would go to their agent, who then could respond. So, but notice is important. Every once in a while, we can't find somebody for whatever reason. Somebody is one of the siblings have just disappeared, and that happens more often than you'd think. And so we have to go through a whole effort to prove we made extraordinary attempts to find that person. We've had situations also where there's been a nasty divorce, and there's been restraining orders. Of course, it's usually the evil husband that's um, um, doing nasty things to the wife. Unfortunately, we've seen that. Hopefully, not a lot, but we've seen that 3 or 4 times over the many years. So it's not a lot. But then we still have to give notice. What we'll do is the court will allow us to hide the address and all the information, and seal the documents confidentially.
Thank you. That's we're caught up on questions for right now.
Okay. Here's a list of the forms. It's 4 pages, and I promise you, I'm not going to go through all of them. But you can see there's a lot, and so when we're doing the conservatorship, of course, we're going to be sending those out and making sure they get completed and so forth. But here's page 1, here's page 2, here's page 3, and here's page 4. Um, the key document, though, is the letters and orders. I'm going to show that to you in a moment. So you've done all this, got the court hearing, you've received the court order and the letters, and you're done, right? No. There is a whole set of documents that need to be submitted. We call them the 90-day documents. They're post-hearing documents. It's you have to give another, it's a separate document you have to give to that gives all their rights, what they can do and can't do. And then there's a level of care, and there's like 2 or 3 documents that need to be completed and filed with the court. And it has to be done within 90 days. We always do it within the first week or two. But if it's not done in 90 days, guess what? The court's going to call a mandatory, what they call a OSC, uh, order to show cause, where you have to come back in court and explain to the judge why you haven't submitted those, and they can fine you up to like first time 500 and 1,500 and so forth. Every once in a while, I'm in court, and there's somebody that hasn't followed up with the paperwork. Um, okay, that's
You
so
have
that's
a question about all those forms. They want to know if that's a county specific or if that's statewide.
So the majority are state, but each county does have specific forms. So yes, so we do conservatorships in Riverside, and a lot in San Bernardino and San Diego and even Los Angeles. I hate Orange County, but we do conservatorships there in Orange County. They're the worst. And so yeah, they all seem to have they all have slightly different forms. Fortunately, they're always available on the website, so generally they're easy to find, and they generally have requirements about what needs to be submitted. Um, so the answer is they're generally the same, but there are differences.
Thank you.
Okay, so again, so we got the post hearing documents submitted. Now we're done, right? Well, no, you're never done. So 1 year later, the court investigator is going to come back out again and do yet another investigation. And usually that 1 year is when the petition was filed. So it's going to be more like 6, 8 months when they come in. They're going to come back in. They're going to meet with the family. They're going to call up the adult siblings, the grandparents. They're all going to get contact. They want to look at the home, make sure it's safe and so forth. So that's 1 year later. Then every 2 years after that, for their entire life, that'll continue. If you move to another county within the state of California, you just need to notify the court. If you want to move out of state, you actually have to get permission from the court. And so that's about a 4 month process. We'll deal with another attorney in that other state, and they have to go into court to get the process started. We notify the court, and then when it's finally completed, then they'll do the transfer over. But it's a back and forth 2 or 3 times. Um,
I have a question regarding that. Since we have a lot of military families, is that, have you encountered that with regard to it interfering with military orders for any of our families that are on military orders specifically, and that process interfering with that?
so we've had this thing, we've had this have such a situation. Not we hadn't have not had it with military orders, but we've had people that have moved and they didn't know about this. And basically, we say, well, you still got to go through the process. Just say you're on a long vacation in the other state. So we'll use something like that. I'm sure the courts, if it's a military move and so forth, the courts they understand that. So the judges are pretty lenient as long as you're making the effort to get the forms done and so forth. That generally has not been a problem. Where they get upset is when they discover somebody's moved and nobody's done anything. That's when they because the courts are actually responsible for the health and well-being of the conservatee, and so they really want to know the documents have been filed. Documents are filed. They're going to be pretty flexible about timing. Here's an example of what the order looks like. I've gone through, I think I've knocked every, put out, hopefully I have blacked out the names. So this is one we did. You can see on the top, we filed the petition, and we must have filed it probably in middle or late 2024. We had the hearing on April 3rd. Yeah, this was down in the downtown Riverside Court. It's a pretty cool court. So it was built in the late 1800s, so it's a real classic court. You can see it was a limited conservatorship. That box is, and was only of the person. It was front of Judge Cohen, who's still there in that courtroom, court number 12, Department 12, and it goes on. And like I said, it's about 4 pages long with various boxes checked. The boxes aren't checked right, they come back and um, hopefully by the time we've got it in court, we've got it. All the documents have to be submitted 4 business days prior to the court hearing, and sometimes the judge will let it go, but it's 4 days. Orange County was like 15 days, which was really problematic. So sometimes we wouldn't get the probate notes in until after the 15-day uh, deadline, which was frustrating. So, anyways, this is the letter, and I think I was just showing you. This is the order, and this is the letters. You can see it says letters on top. And again, we got the other person, limited conservatorship. It was stamped, so that means it was stamped. It was recorded by the court clerk. Farther down, I've only showing the top part. It would be signed by the judge and so forth. So that's the document you would carry around. Maybe you want to carry a couple copies of this, so you can share it if somebody asks. Oops, I did not mean to click that box. So let me pull that back open again. And we'll scroll down. All right.
You do have a question
Okay.
regarding the follow-up investigations. This person says it's been more than 2 years since our last investigation/hearing, and we have not been contacted. Is this usual? Do we need to do anything?
No, that's very unusual. So, um, um, one thing I didn't, maybe the problem I forgot to mention is that you are required to keep your address up to date with the court. So if you've moved or something and not kept your address, um, is this Riverside or some other court county? It doesn't really matter. The same rule applies no matter what county you're in. So you need to make sure the court has your current address, and I would actually contact the court and just it doesn't have to be a formal document. I would just send a note in saying, then have the case number and send it off to the probate department and say, hey, it's been 2 years, I haven't been contacted. Um,
They said Riverside, same address.
Yeah, I would, you know what, I would contact them. I'd send a note. I'd send a note in just to the probate court saying, "Hey, we haven't heard. It's been 2 years. We haven't heard anything." And then just show and just save it, so it shows you've reached out and tried to make contact. The courts aren't perfect. They lose documents, and just like any other organization. Um, So alternatives. What are the alternatives to a conservatorship? Well, the classic one is the power of attorney advanced healthcare directive, just like what every one of you should have in place. And the rule is you should have the least restrictive document in place. So let's talk about these real briefly. I don't have the financial power of attorney. This is just, I think that most people probably knows this. So an individual does not have to be disabled. I have a disabled individual, but it can be anybody, names a person, usually a family member, to manage the finances for them. And it can be immediate or it can be springing. So when we're dealing with our, let's say, high functioning, special needs family member, maybe we don't need a conservatorship. So maybe we prepare a financial power of attorney for them. I don't have a conservatorship over my son. He is relatively high functioning. he answers questions and can communicate. And so I've not sought out, and he's pretty flexible. He's easy, he gets along. So if I take him to the doctor or take him to a bank, he's going to pretty much be agreeable to whatever I ask him to do. And so if you have a situation like that, you probably don't need to go to the time, expense, and effort to do a conservatorship. Financial Power will do the same thing. It names somebody to make decisions for them. It can be what we call springing or immediate. Or in our special needs and family member, is always going to be immediate because you're going to need it constantly. The big however, there's always a however, it's the disabled individual's document. So, so that individual has the power to say, no, I don't want to do that. So you need to have somebody who's going to be flexible. Um, This is what it looks like. Again, there's about 4 or 5 pages long. I've just got the first page. This is a standardized document that everybody uses. We use a standardized document because we want to make sure that people, financial professionals, are familiar with looking at it. It'll go down and talk about the rights and whether it's immediate or not. Advanced Healthcare Directive. The Advanced Healthcare Directive names somebody to make healthcare decisions. Um, Only if they can't communicate themselves. And so that's really important. We're finding doctors are, many medical professionals are refusing to talk to parents unless they have something, either a conservatorship or advanced healthcare directive in place. Really important to have. Same thing with power of attorney, though. It's the um, disabled person's document. So they have the control. They can revoke the document. They can tear it up. You take them into uh, Sam's to get a flu shot, and they say, "No, I don't want a flu shot." Their word controls. So with one of these documents, it's very useful, but you can't make somebody do something. So if you have somebody that's tends to be a child or somebody tends to be resistant, this could be a problem. What I've found in just working with people is some people are very easygoing and so forth. Some people aren't. My son's easygoing. I find a lot of our clients with Downs tend to be easygoing. On the other side of the spectrum, I find a lot of people that maybe have a combination developmental disability and mental illness. So we see that not infrequently. And I tend to find that mental illness issue becomes worse over time. They tend to get more resistant to things. And so if you have somebody like that, I would more guide them to get that conservatorship as opposed to the advanced healthcare and financial power of attorney.
You have a question regarding the power of attorney and whether or not that needs to be updated like the other documents do.
So it's there's no legal requirement that it gets updated. Oh, obviously, if you're going to change people, you're going to change agents, or you want to add people, you got to update it to account for that. But assuming you're not changing the agents or thing like that, there's no legal requirement to do an update. However, um, financial institutions want to see something that's not very distant. So um, um, some people say every 2 years, that's probably too often. But if 5, 7, 10 years goes by, the financial institutions might say, hey, we need to get something that's newer than this. It's just too old or whatever. Or they may also more likely want you to bring in that person. I think they're going to probably be more flexible with somebody with special needs. It's obviously special needs. But unfortunately, powers of attorney are used by bad people. And so, the caregiver brings in the elderly lady and says she wants to withdraw. Here's a power of attorney. She wants to draw $20,000 and give it to me. The bank's going to be all over that. So, yeah. Any other questions on that?
You have a question regarding court jurisdiction for conservatorships.
Mhm.
In this example, the conservatee lives in LA County, the conservators live in San Diego County, and other family members are in Los Angeles. So, what court do they use?
Los Angeles, where the conservatee lives. So whatever they're living is going to be the jurisdiction. The good news about LA County is as big as it is. I mean, LA County just dwarfs Riverside and most of the other counties in the state. They've got a pretty darn good system. I actually find working with the LA County courts one of the best. So, yeah. So what do you do? I kind of talked about this already. The power of attorney, advanced healthcare directive, it's easy to do. It's inexpensive. You can do it yourself. Um, it's powerful. However, the disabled family member can revoke the power of attorney or healthcare at any time. The disabled family member can say, "No, I'm not getting that flu shot. I don't want it." The conservatorship is very powerful. The disabled family member has no authority to refuse or revoke. It is, I put expensive and time consuming. It's not cheap. Uh, um, can you even get one? So if somebody is refusing, you have somebody with mental illness, you have, the older person says, I don't want to be it, and I don't want to be conserved. Now you're looking at a trial. Um, the courts do want the least restrictive manner. If they have if they're mental illness versus developmental disability, if they're high functioning and compliant, POA and advanced healthcare directives probably is going to be adequate. If they can't communicate at all, then have a significant disability, then we're looking at a conservatorship. So ways to get a conservatorship. Do you have to hire an attorney? Absolutely not. You can certainly do it yourself. It's called pro per. It's a Latin term, and it's you're not going to have to you're not going to have to do any sort of exotic legal arguments in court. It's not like in front of the Supreme Court. It's basically it's a paperwork exercise, but it's a big paperwork exercise. So there's just lots of things and boxes to check and so forth. I know lots of people. I've got lots of clients who've done it themselves. Where they're doing special needs trust with us, and they've gone through and they did the conservatorship. So you can do it if you're good at dealing with paperwork and are ready to stay at it, you absolutely can do it yourself. You can hire an attorney. You'd certainly need to call around and make sure that the attorney knows how to do it, is familiar with doing limited conservatorships, and you need to find out what the prices are. I've had a couple of people call me up and say that they called up their attorney and they wanted $20,000. Well, no, that's just that no, no. Um, the Riverside County Bar Association has a low income support. Well, they'll do it, but it's like the limits are like really, really low. They do have a self-help organization through the courts that can be helpful in filling out paperwork. There's also document preparation services, and that'll actually help you to fill out the paperwork. And some of them are excellent. They know what they're doing. And I've been in court when some of them are not. So you just need to make sure if you're going to do that, you find somebody that is experienced and get referrals and so forth. They cannot appear in court with you, but oftentimes, if there's no issues that you don't need to have an attorney representing you in court. So, anyways, lots of ways to do it. I do want to talk about what they call supportive decision making. So this is a thing that was actually introduced a couple years ago. It was actually started by this gentleman, Jonathan Martinez, and he put on a powerful presentation. It's a YouTube video. It's about an hour long that he did presented to another organization. He presented to our special needs conference up in Napa Valley a couple of years ago. And it's a story it's kind of a sad story where there was this young lady with Downs, I believe, who was doing quite well. A conservatorship was ordered for her because it's a kind of a long, sad story with the parents who are irresponsible and so forth. And she regressed dramatically. And it was an example where that I don't think it was the fault of the conservatorship, but it was the fault of the conservators who were not allowing her to grow and take advantage of her strengths. Anyways, so it's a unofficial way to name a person that can, what they call supporters, to help the disabled individual to understand, consider, communicate desires. In this situation, none of the rights are taken away from the disabled person. The supporters don't make any decision, but they can help. Sometimes it's a formal written agreement, sometimes not. Um, um, Here's a chart on the whole thing. I have not done any of these. Um, my feeling is that if they're competent enough um, to do a power of attorney and so forth, and a healthcare directive, we'll go that path. If they're not, we'll do a conservatorship. Um, I can well imagine something like this coming about where we don't, I tend to be a little bit, I'm really black or white. It's either a conservatorship or not, or power of attorney. This might be in the middle area. Um, it concerns me because it's an informal relationship between the the courts, between the supporter and the disabled person. So there's nothing official about it. So there's no piece of paper you can hand somebody. I guess you could hand somebody this for a supporting agreement, but that's some uh, they're not, people aren't going to be familiar with that. And I guess that brings up an important point I want to talk about in the difference between a conservatorship and a financial power of attorney. And that those letters, that conservatorship, that gets going to, as a conservator, that's going to be grant you a lot of power. So let's say your son or daughter is having some interactions with the police for something that's maybe minor or whatever. These days, the departments are doing a better job than they used to about training their officers and dealing with those with disabilities, but it's a long, long ways from perfect. But if there's an issue with the police and you can present a conservatorship, they're going to give you a lot more weight, a lot more leeway than if you just are showing them a power of attorney and advanced healthcare directive. That's another good reason to have a conservatorship if you think it's needed. That concludes my presentation, and ironically, it's exactly 1 hour later. So the official ending is over, so you can leave and go have dinner or whatever, but I will hang around for any further questions for a while.
Yes, you do have a question. This person says our insurance company would not accept our son's power of attorney. Are they just being very strict, or is the language that they do not like?
Maybe both. I'd have to read the power of attorney, but that may be the case. They may not, and then, that there's no, the power of attorney is a legal document, but a private company has the right to not accept it. So unfortunately, I think that does happen. If it involves finances, money, then I suspect they're just concerned about them. They're probably just concerned about them accused of not being careful with the conservatives' money. I can only guess.
Yeah, I personally had that issue with a military power of attorney document and it was a financial institution, not an insurance company, wanting their own power of attorney document to be what they accepted and have that notarized. So maybe it would be worth following up if there's a specific internal power of attorney document that they will accept. That is frustrating.
Yeah, I've seen that, especially if they're dealing with a company that's primarily based out of California and they maybe have like one office and so forth, and they're not familiar with the California documents and so forth. I've seen that happen more often. So yeah, I think that's excellent, Kristen. I think if they have an internal document, that might be just an easy way to resolve the issue.
This person asked, does the power of attorney have to be notarized?
The power of attorney does need to be notarized. The advanced healthcare directive can be witnessed. or notarized, either one.
Right, it just has to be witnessed by someone that's not one of the appointees, correct?
Good point. Yes, and that's true with really whether it's a will or a trust or whatever. People cannot witness a will or be a notary on a trust or any other document if they're named in that document.
All right, let's see. Uh, Someone says this was very useful. Thank you for your time and expertise.
Thank you.
And then this next person says, do power of attorneys need to have your current address if you moved since it was originally made?
So legally, no, but the financial institution may require that, likely to require it.
Probably just good due diligence, huh? I know we're military and it was always hard to update everything every time we moved. Thankfully, we don't move as much as we used to. All right, any more questions? Oh, is the power of attorney automatically in effect once it's made?
Yes. Yep. That's one of the nice things. It's easy and quick and cheap to do that. So yes, the answer is yes.
I think it's good for parents who have just typical developing children who are going off to college to have these kinds of things in place.
Everybody listening here should have a financial power of attorney and a healthcare directive.
Yep.
Absolutely.
Yep.
All right.
Well, I think that's probably a good time to call it. Well, thank you, Jeff, for your time once again. As Jeff mentioned earlier, we have another presentation that he's doing, part 3 of our 4-part series in July. I don't recall off the top of my head the date. I want to say it's that first Tuesday in July.
Yep. Tuesday, July 8th, financial awareness for special needs family. This is
Thank
the
you.
first time I've done a presentation on that, so I'm very excited about putting that together. We'll be talking about able accounts and life insurance and all kinds of interesting things like that. And then on the 22nd, Tuesday the 22nd, we'll be going through all the various benefits. And almost
Yes,
always there's some benefits in there people aren't aware of. So hopefully
always.
we can get you'll find some new benefits you didn't know about. Saves you
Yep.
some money.
If anybody has more questions for Jeff, I will make sure that his email address is in our event on Go Bananas. But I know that his information is also available online and also available on the flyer. Someone had one last question. This will be the last question we take, and then we're going to call it a night. Says, can I find the power of attorney and advanced directive documents somewhere special?
Yeah, pretty much. Yeah, if you just Google Power of Attorney Advanced Healthcare Directive, it's pretty easy to find online. Yeah.
And yes, the presentation is being recorded and will be uploaded to the Nickerson Law website.
Very good.
All right. Thank you, everybody, for your time. We hope you have a wonderful evening. Thanks, Jeff.
Thanks, Karen. Take care. Bye.
All right. Bye bye.